Let us discuss the next question now. This is from the year 2022. Consider the following statements. Statement 1. Pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act was passed. Statement 2. The Constitution of India empowers the Supreme Court and the High Court to punish for contempt of themselves. Statement 3. The Constitution of India defines the civil contempt and the criminal contempt. Statement 4. In India, the Parliament is vested with the powers to make laws on the contempt of court. Which of the following statements are correct? Now, when you are solving this question in the exam hall, when you look at H.N. Sanyal Committee, you may know this or you may not know this because nobody studies so in depth. Now let us look at the easier statements. Going through the easier statements and eliminating the option is the way here. Statement 3 says, the Constitution defines civil contempt and criminal contempt. You would know during your preparation that there is a Contempt of Courts Act and that defines the civil contempt and the criminal contempt. So the Constitution doesn't define what is the meaning of civil contempt or what is the meaning of criminal contempt. So this is incorrect. Now if you remove the statement 3, if you eliminate, we can eliminate the statement C and D. Now coming to statement number 2, the Constitution of India empowers the Supreme Court and the High Court to punish for contempt of themselves. Yes, both the Supreme Court and the High Court have the powers of contempt and that is there in the Constitution. So this statement is correct. Now you know that 2 is correct and anyways 2 is mentioned in both of the remaining options. And also 1 is also mentioned in both of the remaining options. So pursuant to the H.N. Sanyal report, the Contempt of Courts Act was passed. Yes, the H.N. Sanyal report suggested that the Contempt of Courts Act will passed and based on the report, the particular act was passed. So this is correct and it is there in both the options. Now everything boils down to statement number 4. In India, the Parliament is vested with the power to make laws on contempt of court. Yes, the Constitution gives the power to the Parliament to make laws with respect to the contempt of court, and that is how, using that power which is there in the Constitution, the Parliament has made the Contempt of Courts Act. So this statement is also correct. Now the correct answer will be B, 1, 2 and 4. This is how you would solve in the exam, just by seeing some new information. Don't be scared. Just see what is the knowledge that you have and based on what you already know, try to eliminate the options. You can get the right option. Coming for the explanation. It is actually based on the recommendations of the H.N. Sanyal Committee. The Contempt of Courts of 1971 Act was passed. And why is it done? So that more clarity and transparency is based on the concept of contempt of court. The Supreme Courts and the High Courts, they are empowered in the Constitution to penalize for the contempt, and it is mentioned in the Constitution. And in the Contempt of Courts Act, we have two types of contempt, that is the civil contempt and the criminal contempt. What is civil contempt? When you willfully disobey the judgment of a particular court, or you disobey the order or writ or other process of the court, that will be considered as civil contempt. Or if you willfully breach any undertaking or promise that you have given to the court, if you have given a promise in writing, that will be an undertaking. So if you have given an undertaking to the court that you will do something and you willfully breach it, you willfully break it, then also it will be considered as civil contempt. What is criminal contempt? Criminal contempt is when you publish any matter or you do some act which scandalizes or lowers the authority of the court. That is one of the criteria. Or you interfere in such a way when a judicial proceeding is happening. So that is the second criteria. Or you interfere or obstruct the administration of justice in any other manner. So if you do all this, whether you scandalize the authority of the court or you try to lower the authority of the court by publishing any matter, or you try to interfere with the administration of the justice when the judicial proceeding is going on, the criminal contempt will be charged against you. This is the difference, and the criminal contempt will obviously have more severe punishment as compared to the civil contempt. And why the statement 3 was incorrect? The Constitution doesn't define what is a civil contempt or criminal contempt. The expressions, they have been defined clearly in the Contempt of Courts Act of 1971. And coming to the statement number 4, which says that the Parliament has the power to make laws on contempt of court. Article 142 clause 2 says, subject to the provisions of any law made in this behalf by the Parliament. The Supreme Court shall, in the whole of territory of India, the Supreme Court shall have the power to make any order for the purpose of securing attendance of a person, or for the discovery or production of any documents, or the investigation, or the punish the person for the contempt of itself. So based on the powers given here, the Parliament has made the Contempt of Courts Act of 1971. So the correct answer for this question is B, 1, 2 and 4, because the Constitution doesn't define what is civil contempt and criminal contempt.